How does the Trump administration's antitrust stance, coupled with emerging state-level regulations, impact life sciences companies? So if you're in legal, if you're a compliance professional, or are otherwise interested in the pharma sector, this episode is essential listening. Let's begin with the federal landscape. Assistant Attorney General Gail Slater, in her inaugural antitrust address at the University of Notre Dame, she came out and emphasized that antitrust enforcement is a core element of what they're going to focus on, and it's not just pure regulation, it's actually legal enforcement. This approach signals a return to traditional antitrust principles, where they're focusing on clear statutory violations rather than broader regulatory interpretations. This seems to go back to what the Trump administration has said over and over again, that they don't want to exceed what the law actually allows for. They are looking at interpretations, but they are looking to go back to the core written authority itself under the actual core law. For life sciences companies, this means heightened scrutiny of mergers and acquisitions, especially where there could be a consolidation of market power or limitation of competition. On April 4, 2025, Washington State also enacted SB 5122, and it became the first state to implement a broad pre-merger notification law. And this covers transactions across all industries. Effective July 27, 2025, this law requires that companies meeting certain thresholds must submit copies of their Hart-Scott-Rodino or HSR filings. This must be submitted to the Washington State Office of the Attorney General, and specifically this law applies if a company has, number one, a principal place of business in Washington, number two, achieves net sales in Washington of at least $25.3 million, which is 20% of the current federal HSR threshold, and number three, is a healthcare provider or provider organization as defined in state law. Notably, companies headquartered in Washington must submit the attachments to the HSR form. The Attorney General has the authority to request these attachments from other filers within 7 days. While SB 5122 does not impose a filing fee or a mandatory waiting period, failure to comply can result in civil penalties of up to $10,000 per day. So it's obviously something you should be listening to. So what are the implications for life sciences companies? For life sciences companies, there are significant implications. Number one, increased scrutiny of M&A activities. Both federal and state authorities are signaling a more aggressive stance on M&A. Transactions that may have previously escaped detailed review will now face closer examination, especially if they involve entities operating in Washington state. Compliance within multiple jurisdictions. Washington is not the only state that is affected. New York and California are considering similar pre-merger notification laws. So companies must be prepared to navigate a complex web of state and federal regulations. This necessitates a comprehensive understanding of each jurisdiction's requirements to ensure compliance. Strategic planning. Legal and compliance teams should proactively assess potential transactions for antitrust risks. This means both looking at federal enforcement priorities and emerging state-level regulations. As you know, Massachusetts had something related to healthcare law. In the context of M&A activity, that may be relevant. Early engagement with antitrust counsel can help identify and mitigate potential issues before they escalate. To navigate this evolving landscape, life sciences companies should consider the following steps. Number one, conduct thorough antitrust risk assessments. This means evaluating current and planned transactions for the potential antitrust concerns and consider both federal and state regulations. Monitor legislative developments. Stay informed about new and proposed antitrust laws, both at the federal and state levels. This includes tracking regulations and legislation in states like New York and California, which are exploring their own pre-merger notification requirements. Number three, enhance internal compliance programs. This means developing or updating internal protocols to ensure timely and accurate filings with the relevant authorities. This includes establishing clear lines of communication between legal, compliance, and business development teams. And then obviously engage with antitrust counsel early. Involve your legal experts in the early stages of the transaction planning to identify potential antitrust issues and develop strategies to address them. The Trump administration's antitrust enforcement approach, combined with emerging state-level regulations like Washington's SB 5122, presents new challenges for life sciences companies. By proactively assessing risks, staying informed about legislative developments, and engaging with legal counsel, companies can navigate this complex environment rather effectively. Thank you again for joining us on Deep Dive from the Kulkarni Law Firm. Stay tuned for our next episode. We're going to continue to explore the legal landscape shaping the pharmaceutical and life sciences industries. Call, click, or email